Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in two cases this morning. First is 21-1047, Fortenberry against the Great Divide Insurance from Dallas County and the 5th Court of Appeals District. And second is 21-534, the University of Texas System against the Franklin Center for Government and Public Integrity from Travis County and the 3rd Court of Appeals District. Justice Blacklock is not participating in the decision of that case. The court has allotted 20 minutes for each side in each of the arguments, and will conclude them this morning. The arguments are being webcast live on the court's website and will be available in the archives later today. We're ready for argument in 21-1047.
May it please the court, Mr. Collins will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court, we're here today concerning the definition of the word residence in the Texas Workers' Compensation Act as it relates to the venue as to where a party can appeal a decision from the administrative agency. First, we contend in this case that the 5th Court did not follow the proper standard of review that this court described and set out in Ruiz versus Conoco back in 1995. Secondly, we say that the 5th Court improperly required Fortenberry to prove that his stay in his room there at the Residence Inn in Irving was a permanent residence. We say that that is too restrictive a reading of the requirements under the venue matter or the venue provisions of the Workers' Comp Act.
And so what would you propose that the rule be? Because clearly if you have a home and you're going to a city and you're going to stay in the Four Seasons or wherever you're going to stay, that's not your residence. So, but then on the other hand, you know, there are times where it could be. So where's the line in your opinion? Your
Honor, amazingly, we say this court in Brown versus Bolin in 1857 put it quite succinctly. If a person's affairs are in such a state of flux that you can't really determine precisely where the location should be, or in that instance, the domicile, if you will, we say that in either county, either the domicile or the residence can provide the proper standard for determining the venue. And very candidly, it's becoming a very rare kind of situation in some instances where this is even an issue. As a matter of fact, I can't remember the last time this court addressed a venue decision in a workers' compensation matter. So it's something that I think that the court early on understood required some degree of flexibility, where a person is moving from one county to the next, or in Mr. Fortenberry's instance, where he's moving from college in Lubbock to Dallas to begin his NFL career. And he was only in the state, or excuse me, only in Dallas County for a proper 2, 3, 4 months prior to his August injury at training camp out in Oxnard, California. So we think that the court, by requiring a permanency element, is going to rule out a lot of people. For example, truck drivers, people in the oil and gas industry, drilling fracking wells out in West Texas and other parts of the state. They quite often reside in temporary locations and trailer camps or motel rooms where they're moving from one rig site to the other. It's hard to determine exactly where the county of residence is. And in this case, in Mr. Fortenberry's case, under his standard player contract, the team, the Cowboys, paid for his temporary housing there during the start and the beginning of his rookie season. So we say that that particular standard is one of flexibility. And this court has said that on more than one occasion.
Is there any evidence in the record about how long that would have gone on if he had not been injured? Would he have stayed there all, you know, do the Cowboys do that for the whole season or multiple seasons?
Well,
Or are they expected to get an
Your
apartment?
Honor, that's very interesting, because generally speaking, at the end of the training camp, at the end of August, the training camp roster is cut down to where it's down to the 52-person roster. And so in our position, we think that Mr. Fortenberry had a very good chance for continuing on, simply by virtue of the fact that on the very day of his injury, on August the 2nd, 2015, the team decided that they wanted not to cut him, but they wanted to put him on the injured reserve roster. They thought that he had potential to come back, and so they put him on the injured reserve roster, and we think that's some evidence that the team recognized that he had talent that would certainly assist in making the team. So those are factors that we say go in his favor. And in the...
Is any of that in the record, the information about likelihood of making the team, or sort of how these rookie contracts tend to work, how often they end up being actual 3-year contracts? Is any of that in the record?
No, Your Honor, there's not. And as a matter of fact, there's, in my experience in dealing with some of these cases, there is no indication as to whether or not a person can, you know, make the final roster, especially with a rookie. But, you know, some players negotiate a provision where they have sort of a no-cut contract. That's one, one indicia of whether or not the team thinks he's going to be, have the potential to make the roster.
Was he drafted?
I think he had to be drafted in terms to get an invitation to come participate, but that's not clear in the record, Your Honor.
What do we make of the ALJ's finding that Dallas was the proper venue, at least for purposes of the contested case hearing?
Well, that's the irony of this case, Your Honor. The irony being that, yes, there was, quote, venue for the contested case hearing, but that was, that was stipulated in the record. Now, the standards for determining venue for those administrative hearings, of course, is different from the statutory provision on the residence. So, but we think that that's an important indication of where the venue ought to be, especially coupled with the venue provision in his standard player contract. Now, we think the Fifth Court misinterpreted our argument about that. We're not saying that Great Divide was bound by the contract. However, it's an indication of the party's intent. In other words, it's evidence that that's where they thought the focus of any litigation ought to be. And of course, in his instance, it made a lot of sense. The place, the residence inn, the Great Divide claims handling office, and the Cowboys literally were all within a 5-mile radius of Dallas County. And so it's very compact in terms of who the players are, the party's interest. So they're all right there. And so we think that's another factor that the court can evaluate, because as the court indicated early on in the Brown-Bolden case, these provisions for venue were primarily to protect the defendant, to keep them from being sued outside the county of their residence, outside the county where they have connections. And so it was primarily designed for that. And if you use that as a standard, everybody's here in this case is in Dallas County.
Well, I understand the point that the insurer was not bound by the venue provision in the NFL contract, contract between Fortenberry and the Cowboys. But what about this provision of the labor code that tells us that a stipulation of the parties that is made, is preserved in the record, is final and binding? I mean, you did make the stipulation in the trial court that venue had been proper in the Dallas field office, Department of Insurance, Division of Workers' Compensation. Is it your position that that's binding?
Yes, it is, Your Honor. It's our position that it's binding. However, the factors that go into where they decide where to have a venue hearing, and especially back in the Zoom days, they would have hearing officers all over the state. And even before that, the way the division handles the initial location is primarily if the person is out of state or an in-state resident. And my recollection is there is a rule that the hearing has to be within a reasonable distance from where the injured worker is.
That's right. And the venue provisions are different, but they are at least, I think, meaningful here. The stipulation is meaningful because at a minimum, it seems to suggest that the Irving field office was not more than 75 miles from the claimant's residence at the time of the injury. So that seems, at the very minimum, to exclude Travis County as the residence. That's more than 75 miles from Irving.
Yes, Your Honor. And we totally agree with that. I just think that we're going to have a different position from Mr. Brenner when he gets up here about that. But certainly, we think that's another big factor that this court can consider in deciding the case.
Let me ask you about 410-252C of the Labor Code venue provision. It says if suit's filed in another county and the court determines there's no jurisdiction to render a judgment on the merits of the suit, then it should be transferred to the court in provision B, which is the county of residence. What should we do with that word jurisdiction?
Your Honor, I'm not clear about what the court ought to do. However, that provision, of course, is interesting for several reasons, part of which is that if this case goes back to the trial court for venue, where are they going to send it?
Well, maybe they don't have to send it anywhere if the court has jurisdiction. That's why I'm asking what meaning we should give to that word jurisdiction, because there's no dispute, I don't think, that the Dallas County Court had subject matter jurisdiction.
That's
right?
correct. That's correct, Your Honor. And
so do we even look at 15002, the general venue rule? Does the Labor Code even allow us to do that?
I don't think it does, Your Honor. I think it's sort of it's an unusual wording that I've seen in the venue statutes of this state, but it says it must go to there is no permissive venue under that provision, the way I read it, and that makes our dilemma here just a little bit unusual, like I say. So if we go back before the trial court, to what county is the court going to send it?
What's your experience with what trial courts do under Rule 87.3D, where it says if neither party establishes venue, the court may order parties to make further proof? Does the court have to do that? Or, I mean, it's a motion to transfer. If the movement doesn't carry their burden to show that it should be transferred to another county, then should the motion just be denied, or is it an abuse of discretion for the court not to order the parties to make further proof?
I think the parties are going to have to make further proof. In this case, Your Honor, I don't think we have.
Well, I guess unless the Labor Code doesn't allow you to look at 15002.
That's correct. And I have found no authority, no hint, no law review articles, and nothing that addresses that issue, Your Honor. So we're plowing new ground, literally, in that direction.
When was the suit filed
The
relative to the injury?
The injury is August of 2015. I want to say 2017 or 18, Your Honor. I don't have that date right here in front of me, but I can get it for
I
you.
believe there was evidence that he was still living in Dallas County at the time the suit was filed.
Yes, Your Honor, there's
So
no
should
dispute.
should we take that into account in sort of gauging the genuineness of the claim that the initial residence at the hotel was intended to be lengthy or permanent?
I think that's a fair inference from our perspective, Your Honor, I do.
I just want to make sure I have the dates correct. So his injury was August 2nd,
Yes, sir.
and he had just gone to Oxnard a day or two before.
Yeah, about 2 or 3 days, Your Honor, something like that.
And then after the injury on August 2nd, how long until he came back to Dallas?
He flew back he stayed in Oxnard a couple of days, and I think the record reflects is he flew back under Dr. Cooper's direction on 2 days later on August the 5th.
So he was actually in Oxnard not even a week, like 4 or 5 days. He got
That's
there a
correct,
couple
Your
days, got injured, a couple days later came back. During those 4, 5, 6 days, did the Cowboys continue to pay for the hotel room in Dallas? Did he still have that hotel room?
Your Honor, that's not in the record.
Okay.
We simply don't know.
Okay. Any other questions? Thank you, Mr. Collins.
Thank
We'll
you,
hear
Your Honor.
from the respondent.
May it please the court, Mr. Brenner will present argument for the respondent.
May it please the court, there are a lot of questions that the court asked, to which there are answers that this court and other courts have addressed. But first, I'd like to go over the Snyder versus Pitts holding. Snyder versus Pitts set 3 standards for residence as opposed to domicile. Domicile is our permanent home, where we live, where we vote, where we keep permanency to our life, our family, and everything else. The court recognized, and it's unique to Texas because I did a search of all states, and most states correlate residency to domicile. Texas, for the last 150 years, has held that you can have a second residence, and if you have a second residence which doesn't have the same standard as a home, you avail yourself of that jurisdiction for purposes of suing or being sued, and therefore,
So
a second
let me ask you something, please.
I'm sorry.
So if this gentleman would have had a home that he was buying in Dallas, would you say that you would lose?
I would lose. It depends on whether he has actually completed or substantially completed his move. And in
Well,
how
let's say if he had,
if he had, clearly, it would be his residence
So
and his domicile.
So if he were, let's say if this argument really hinges on the fact that he was in a hotel and the permanency of that, let's say if he decided that he was going to move someplace else, where would it have been?
The record is completely silent of where else he would have moved.
But wouldn't it have to be in Dallas?
The record is also silent on that. In fact, outside the record, we know that there are football players who live in Arlington, who live in Dallas.
Austin?
Arlington.
Would it have been Austin?
Well, Austin is an alternative venue choice, so it doesn't have to do with his residence. So the courts of appeals have held that when a mandatory venue provision does not apply, which deals with his residence, then you default to permissive venue. Permissive venue is where the accident occurred, which is in Oxnard, California. Permissive venue is where the defendant has a principal office or principal agency, which is why we asserted Travis County under the alternative venue statute.
But why does 410.252 allow you to do that?
410-252, I think this goes back to your question about jurisdiction. This court has held time and time again that although the statute addresses jurisdiction, it is not a question of subject matter jurisdiction, but in fact venue. And although the legislature addresses it as jurisdictional challenge, for example, the 45-day filing period is a limitations provision, not a jurisdictional provision. The venue provision is a venue provision, even though it says jurisdiction and not a jurisdictional provision.
But the legislature knows how to say venue.
They do, but this court disagrees with their use of it.
Which case is that?
I can give the court the site of about 4 or 5 different cases. I didn't bring them because I wasn't prepared for that question, but I know that the court has done it on numerous occasions, time and again, saying that when you're addressing a district court's jurisdictional ability, it has general subject matter jurisdiction. And so it no longer reviews, for example, election of remedies as a jurisdictional bar, but as a plea-in bar that would be subject to summary judgment.
Well, let me ask you this. Since you moved to transfer venue to Travis County and the Court of Appeals held that you hadn't proven what you needed to prove in order to establish venue in Travis County under 15002, assuming for the sake of argument we agree with that, why wasn't it not an abuse of discretion for the trial court to deny your motion?
Well, because venue was not appropriate in Dallas County. And so
but you're moving to transfer it to some place that's not appropriate, which should not be granted.
that's correct. But on Ruiz versus Conoco, this court held that inappropriate venue is error as a matter of law and mandate to reverse it.
There was dicta in that case about that, but
Yes.
what about the provision of Rule 78 that says the trial court may have the parties, 87.3D that says if neither establishes venue, the court may order the parties to make further proof.
That's correct.
Why is may must?
I can't answer that question for the court. I believe that that is what precedent, the appellate precedent shows, is that if there is, and the Court of Appeals cited to the precedent, that when there is not proof that either venue asserted, the court needs to do further findings to find where venue would be appropriate.
That seems totally contrary to the adversary system, where the parties are asking the court to do something, and it seems like what the Court of Appeals was saying is, well, the trial court now has to take over the case and go hunting for the proper venue that nobody has asked them to find it in.
Well, I think if you file a suit in a county that has no venue, and the parties seek to transfer, the court has to make a decision on where proper venue would lie. And I believe that's what the Court of Appeals ordered. We disagree with the Court of Appeals' assertion that Travis County is incorrect for many, many reasons. We didn't brief that because it wasn't elevated to this court. But we do believe that when it goes back to the trial court, we can establish why in a workers' compensation case Travis County would be appropriate.
You mentioned the Ruiz case, and do you agree that in looking to determine whether there's evidence of proper venue, we should examine the entire record?
Absolutely.
Okay.
And
then you mentioned Snyder, and Snyder with the follow-along cases in Powell and Mills. Are we looking for evidence of intent to remain?
no.
No.
And the reason you're not looking for that is because
So that has nothing to do with the analysis, whether there's some intent when you're in a county and whether you have an intent to remain is not part of the question.
It is a question for domicile, and Snyder makes it clear that it's a question for domicile. It's not a question for residence, and Snyder addresses that too. There are 3 factors: a fixed place of abode with possession, and they equate possession to a right of possession equal to paying rent, a leasehold, or owning the property. Occupied or intended to be occupied consistently over a substantial period of time, and then which is permanent rather than temporary. And here, there is no evidence of how long he intended to reside there or whether it was permanent. In fact, there's no evidence that he...
Is obligating yourself to a 3-year employment contract some evidence coupled with, when it is coupled with occupancy
It
in the
would-
county? And then, I mean, how much evidence do we need in examining the entire record to conclude that there is sufficient evidence to
Sure.
establish venue in Dallas County? Because
so-
you're asking us to reject, you know, that he was paid in Dallas County, that he performed work in Dallas County, that after he was injured, he returned to Dallas County, and that he signed a 3-year contract with an employer in Dallas County. And we're to reject all of that as no evidence of public
Sure,
venue.
and the courts have done that time and time again. And if you look at the 4 cases we cited, you'll see that the courts focus on residency as to whether you reside there, you actually live in the county, not whether you work there. And there are many cases where people work and have businesses in certain locations, but don't reside in that location. And so therefore, for example, in Howell versus Mozzie, and again in Van Hoos versus Moore, and Burke versus Merrill Lynch, the location of their business ventures were insufficient to create a venue. They
And that makes perfect sense, but if we're trying to determine whether the occupancy in Dallas County is permanent or transient, could these other pieces of evidence that have to do with location of work and payment, address of the W-2 and those sorts of things, lend some evidence from which a fact finder could conclude that the occupancy was intended to be permanent?
The answer is yes, generally. In this case, no, because in this case, all of those documents deal with Mississippi and address Mississippi as his occupancy and domicile. His employment contract and his player information sheet addresses his home in Mississippi as his address. His W-2s in the record show Mississippi as his address. His tax return show Pennsylvania and some agent in Pennsylvania as his address. There is no record on the date of injury. Certainly months after, there are records showing residency in Dallas, but on the date of injury, there is nothing in the employment contract or those records that show Dallas as his address.
Were his travel expenses to California paid as though Dallas was his home city?
The record is silent on that. The record does show that the team traveled on a charter 5 days earlier to Oxnard, California, but whether or not the players came from Dallas or Fort Worth or Arlington or Plano, the record doesn't address that at all.
Is there any evidence in the record of the likelihood of either this particular 3-year rookie contract or such contracts in general, actually continuing for 3 years?
The contract addresses its term, and it is not a short-term contract. It's a long-term contract for employment with the Cowboys. And so, yes, there's evidence in the record regarding the term of the contract, subject to performance, subject to many, many conditions.
So you would say we would look at this like any other 3-year employment contract and not as, something particular to the NFL or NFL rookie contracts?
I think you look at you do a 4-corner contract analysis on any contract, whether it's.
But you're not arguing that this contract is less indicative of permanency than any other employment contract would be?
I don't think the contract has any reference to residency at all. There is a contractual venue provision for disputes arising out of the contract. The workers' compensation claim is not one of those things because it's not between the Dallas Cowboys and Mr. Fortenberry, and so therefore it doesn't apply.
Well, it doesn't bind you, but certainly you'd agree it is some evidence that it's where Mr. Fortenberry intended to perform the contract, intended to have any dispute related to the contract adjudicated.
I'm not sure that it is, and the reason I'm not sure that it is because although the Dallas office was based in Dallas, the Dallas Cowboy playfield is not necessarily based in Dallas, it's based in Tarrant County. And so, and it doesn't address where he intended to live or has no requirement of where he intended to live. It does address who he intended to work for. but not venue with regard to residency, which is the key factor.
Could you address the effect of the stipulation
I-
that while it was initially made in the ALJ proceeding, was repeated into the record in the district court?
Yes. The ALJ proceeding venue provision is different from the judicial review provision. The 75 miles on the date of the hearing is to accommodate an injured worker when they have hearings and to make sure that they have a location nearby.
Well, that provision that you've just referenced says the contested case hearing may not be conducted at a site more than 75 miles from the claimant's residence.
Right.
At the time of the injury.
Okay. I understand. The
And-
410-2, and the way it's applied, however, is that they conduct it and change it regularly from the date of the hearing and at the administrative level. And so you may have a Dallas hearing, but if the claimant moves, they accommodate his move. And so at the time of the hearing, after the date of injury, it is clear that Mr. Fortenberry did move to Dallas and obtain residence in Dallas. And that's in the record, in the record. And so we don't believe that that has any effect on whether Dallas was the place of residence where he lived at the time of his injury.
Is it your position that what needs to be permanent is the occupancy of the hotel as opposed to the intent to live in the county?
It's case law's provision on that, yes. Case law's provision looks at where he's staying or where the individual, he or she is staying.
So let's say I sell my house in Travis County because I think I'm getting a good deal. I don't have anywhere else to live, but I move into a hotel in Travis County while I look for another house. Do I reside in Travis County while I'm in that hotel?
No, because the hotel's a temporary residence, unless you intend to reside in the hotel for some permanency.
So I had a house in Travis County. I'm temporarily in a hotel in Travis County because I've sold my house. I'm looking for another house in Travis County. I've lived here for decades, intend to live here for decades, but because I briefly lived in a hotel at the time of the injury, I do not reside in Travis County.
No, I think the problem with the scenario is that residency implies something other than a permanent domicile. And so permanent domicile for Texas and for venue purposes is your permanent home where you're registered to vote, where everything occurs. And so under that scenario, you're permanently domiciled in Travis County, you're in transition within the county, and so you're not really dealing with a second residency. Residency.
So is your answer yes or no? Do I reside in Travis County while I'm in that hotel?
I think you're domiciled in Travis County. I don't think it's a residency question.
No, but I mean, if there were a residency question, what would the answer to it be?
The answer would be that if it's a temporary dwelling place, it doesn't qualify as your residence.
And so I have no residence for venue purposes during that time I live in the hotel?
I don't think that's accurate. I think you're domiciled in Texas, and domicile.
Right, but your position is that domicile and residency are separate, and so I'm talking about residency. Is it your position that during my time in that hotel, I would have no residence for venue purposes?
I think that hotel can't be your residence. I agree with that. And I think that's what the courts have held in the 4 cases we were looking at, and that is that a temporary residency, a temporary hotel stay, that location can't be your residency because there must be some permanency to the stay.
If you're wrong about that, and if the law looks not to the permanency of the abode itself, but to the permanency of of your living in the county,
Sure.
if that's how the law works, do you lose this case?
No, and the reason I don't lose is because if you look at the very first case, Brown versus Bolden, there was and this goes back to the beginning of the court separating domicile from residency. The person was in the process of moving. He acquired a second home, but hadn't moved to that home yet. And he still had family and belongs in the first home. And so because he hadn't acquired it and didn't establish some permanency yet to that home. It was still temporary. The court held it didn't, this court held that it didn't meet the residency standard. And so
If the
ultimately,
person had moved and had been there 2 or 3 months, would that have been enough?
if the person had
Had
moved
moved,
and
right.
intended,
And it had lived there in the new residence 2 or 3 months.
so
And isn't that what we have here?
no, we don't have that here because we have.
How long did Mr. Fortenberry live
It's
in?
absent in the record. We don't know when he went to the hotel. We don't know how long he was there. We don't know if he was there for 2 days or 2 weeks or 1 month. The only thing in the record that is there that talks about length of time is on page 103 of the record, and that's the affidavit from the Dallas Cowboy representative that says that it was a temporary housing solution and not a permanent housing solution.
But the record does tell us that he was attending training camps, training activities in the months of June and July 2015. And, I mean, you concede and you agree that took place in Dallas, don't you?
That the record's silent about that. We do have a schedule that it's in the record on page 106 that shows where he was in July 26th, and the record shows that they went to Oxnard on the 28th, and it shows that they were going to be there for a couple of months. I think the return date was August 28th. And so it looks, that's what's in the record. There is nothing in the record to show that he was actually attending training camp in Dallas or elsewhere. It's just silent in the record.
Does the record tell you where June and July 2015 training camps were held?
It was not in the record, no. And so the only reference to this hotel is his statement, I was provided that hotel, and then the affidavit from the Dallas Cowboys saying it was temporary. There's no indication he ever returned to the hotel, and there's no indication he was there for more than 1 day or any days at all, because the record is totally silent of how long he was there, when he was there, or how long he intended to be there, or whether he would ever return.
We don't know if he checked out before going to California.
We don't know if he checked in or checked out.
It's interesting that the hotel's name is Residence Inn.
It was David's Residence Inn, which is ironic, yes.
If it had been an apartment house owned by the team, and they said, look, anybody who's on our team, you can have an apartment here at our apartment house while you're getting situated. Any difference there, or would it?
It goes over factor one, and that's the fixed place of abode. And when the courts have looked at a fixed place of abode, they talk about some right of possession as opposed to a licensee. So for example, an Airbnb or a hotel is considered a licensee and no right of possession. A rental agreement is. And so if there's a rental agreement that shows a right of possession, it demonstrates not only some permanency, but also that it rises to the level of abode under the 3 Snyder factors.
Any other questions? Thank you, Mr. Brenner.
Thank you.
Mr. Collins, you have 5 minutes.
Thank you, Your Honor. Just briefly, I think Mr. Brenner's answers to your questions illustrate the rigidity that Great Divide seeks to impose on the Workers' Compensation Act about how long you stay in a hotel, do you move, do you stay, are you leaving, are you checking out? In Snyder versus Pitts, Cecil Snyder lived in Vernon. He worked in Dalhart for 12 to 15 months. Guess where he stayed? In a hotel part of the time, and rented a room in a private residence for the balance of the time. And the court held that he can be sued in Dalhart. And so we think that the Snyder versus Pitts factual scenario supports our arguments in this case, namely that there must be flexibility. And each individual circumstances, or person's or individual circumstances are unique. For example, in a number of professional sports, baseball, football, hockey, soccer, all of these professional athletes in Texas, they get traded in and out of this state on a daily basis, literally. And it's not uncommon, say if you have a real playoff game coming up, say in baseball, that you'll sign a pitcher in New York and you'll put him on the plane overnight to pitch the next day out in Arlington Stadium. And so if he's injured there, and he stayed in the hotel, under Mr. Brenner's scenario, he can be injured but won't have any place to bring his lawsuit. So that's why we suggest that the court take a good look at the flexibility that's required, especially in the workers' compensation setting, where people are moving, searching, going to new jobs on a daily basis. Thank you, Your Honor.
Thank you, Mr. Collins. The case is submitted, and the court will take a brief recess.
All rise.